Good afternoon or good morning, I guess, still, Andrew and Cindy and Spencer. This is Barrick. I'm just going to give it a few more minutes to get a couple more of our members on. Good morning, Tom. Good to have you on.
Morning, Barrick and everybody else.
Good morning, everyone.
Hello, Andrew. Hello, Spencer. Good morning, Lauren. Hey, Carrie, do we know, are we expecting Alana and Ian today?
Sorry, Barrett, can you say that again? I'm having some audios.
Do we have any reason to not expect Alana or Ian today? I know we had some folks traveling.
I haven't heard from either one of them, so hopefully they're able to join.
It's going to give us another minute or two. I will say, folks, I know we got you a lot of that stakeholder input with not much notice to read through it. We wanted to try to get as much time for folks to weigh in while getting us prepped for today. So we'll spend what time we need talking through that feedback today. I'll give a little bit of an overview as well as share some general feedback from the administration as soon as I give it another minute or two to see if we get one or two more folks on. I see Ian is connecting now. Good morning, Ian. You know what? We have the vast majority of our folks. Alana may still join us, but we have a good amount to get through. So I'm going to go ahead and get us started. It's going to sound a bit like a broken record to some who are used to this opening spiel. This is Barrick Abramson with Confluence Policy and Strategy Group. And this is the October 28th meeting of the COTA Rewrite Subcommittee of the 1296 Task Force on the Rights of Coloradans with Disabilities. A few norms as we start. Members, and I see you're all already doing it, we do ask to the extent that you're in a place that it's safe and comfortable to do so, you have your cameras on. Certainly understand if you're not in a place to do so. Members of the public, we appreciate you joining us. We will have opportunity for public comment at the end of today's session. We would ask that you leave your camera off until then. When we get to public comment, I will ask you to drop a chat to Carrie Steele or myself, Barrick Abramson, to let us know you'd like to speak to the group. Last thing on that chat is we ask everybody else to refrain from using it. The chat can become distracting, certainly for folks using a screen reader technologies, and frankly, the chat just gets distracting for the good conversation itself. Last thing I will ask is members, the first time you speak, if you would introduce yourself by full name, and anytime after that, just introduce yourself by first name for anyone just listening into the audio of that. With that, let me go over a little bit about how we're going to approach today's conversation. As I said, I will first share just a general overview of the feedback we've gotten in. We'll go into some discussion or points of clarification for those of you who have had a chance to get into that folder and read some of that. We're going to then start going through all of the ideas one by one. We'll start with talking through what turned up as Survey 2, but it's the topics of emotional distress, of timelines, and of caps. With each of these, I'm going to do an initial pulse check vote. And by that, what I mean is I'm going to ask everybody to vote in one of three ways on each idea individually. Number one, having heard the feedback, having read what stakeholders had to offer, I either number one, want to advance this idea as a recommendation substantially as we originally drafted and shared it, or with minor revisions based on input. Option number two will be, I want to consider advancing this with substantive revisions for discussion. Or number three, you'll have the option to vote, having heard the feedback or thought about this myself, I think we may want to include it in the report, but I don't think it should be a recommendation of the subcommittee. So three votes. Number one, yes, with no or minor revisions, let's make this a recommendation. Two, it's in need of substantial revisions, but I think it should be a recommendation. Or three, let's report it out, but not as a recommendation. If we get to any where we don't have unanimous votes on these, I want, number one, everyone to be very comfortable voting in opposition to something that your peers are voting in favor of. Carrie and I will capture if you'd like to offer the reasons you're voting against it. You also have the opportunity to send us by email or a private conversation an explanation that you'd like to include in the report. While these calls are all video recorded, so people can ultimately go back and look at any one of these votes, our report will simply have what the vote tally was, and if folks have asked for a dissenting or minority opinion, that will be included. We will get through as many of the ideas as we can today. I expect we're going to get through about half or a little bit more, and we'll continue this in 2 weeks, which is why we needed to schedule some more conversations. I do have informal, at this point, feedback from the administration, the governor and the executive agencies. They're still themselves working to finalize it across all of the different state agencies, but I'll share that. I will, in full transparency, say as I start to share out the general responses that we got, we didn't receive a whole lot of recommendations or feedback with specific recommended changes. We didn't get a lot, as you probably saw if you had the chance to read through, of I like this, but it would be better if you did this, or I dislike this, but if you did it this way. What we generally heard was either general expressions of support or general opposition or concerns. At the risk of oversimplifying it, the concerns we heard were some of the following: that emotional distress, in some words, was unquantifiable and difficult to remedy that way. We heard from some folks, some stakeholders, and I am emphasizing where people opposed it because where it was in agreement, it was generally, I support this idea. So I'll get to that. So I'm first starting off with people who had concerns. There were some stakeholders who shared letters or through the survey, as you saw, that said we worried that this would create more lawsuits, would create greater uncertainty for business owners, or would open them up to unknown types of risk. We had some more narrow concerns about should we be incorporating language directly by reference. I'll go through some of those, but the general concerns in opposition were whether we were going to create a hostile environment for business. Would this create new litigious environments and new lawsuits? And could it be risky to businesses who wouldn't know what those damages were? I'm going to go through next just some of the general feedback from the administration. Then I'm going to pause because I already see people having gut reactions to some of this. When it comes to codifying agency deference, and you'll remember we talked about the Chevron decision, the administration's general thoughts are that this would require very thoughtful and specific language to make sure we maintain consistency with state agency process. On our ideas of the filing deadlines, there was some concern from the administration, from the Attorney General's office, and from others whether 3 years was too long. Some thoughts about record retention. Some stakeholders gave feedback that, in their own words, memories fade and 3 years seems particularly longer. When it comes to the definitions, once it was pointed out that the definitions are largely from the ADA, we didn't get specific concerns or objections there. There was some questions about the idea floated to incorporate directly federal regulations into state law, but a desire to generally see if we can't find a middle ground in a way that continues to protect Coloradans' rights while maintaining the integrity of the rulemaking and regulatory environment. I think the place we got the greatest questions, other than general questions about new types of litigation through emotional distress or the uncertainty of removing caps, had to do with exhausting administrative remedies, and particularly around compliance and adherence with agreements that the state has with the EEOC, and where there may need to be federal alignment there. Generally, on emotional and punitive damages, it was a very split set of input. And I know you've all read, so I'm repeating some just for the benefit of jumpstarting this conversation. There were some stakeholders that said yes, there are damages that occur that simply cannot be redressed in other ways, and you cannot remedy the situation, so emotional distress damages are appropriate. There were some who flatly disagreed with that, who said that you're opening up a new stream of uncertainty and in some eyes, the risk for a frivolous lawsuit or litigious environment. And the same comments came in on the punitive damages. Those were in support, were in support. Those who opposed it said that you were creating more uncertainty. I'm talking through all of this longer than the words actually were, all to say there was not, from our read, a clear leaning of stakeholder feedback that landed one way or the other. I didn't see, but I want to then open it up to the group. I didn't see where somebody brought to us a new way of thinking or a new way of approaching what you all have put forward. So it's really going to be for this group, having spent the last year together, having heard from a number of folks, and now having heard from the advocacy community, from individuals with lived experience, and from the business community of where we want to put our recommendations forward to the executive committee. I am going to ask our partners at DORA if there's anything they would like to add to the conversation, particularly as it relates to administrative remedies or government immunity. Ginny or Aubrey, did either of you want to offer anything? There you are.
Barrick. Hi, everybody. Yeah, so thanks, Barrick. I did just want to jump on and let everybody know that we do have quite a volume of responses to get through. I did want to point out, though, in full transparency, that the piece on the exhaustion of remedies, that we did provide a factual presentation on April 8th, and even though that idea did come forward, we did want to also remind folks that that would require a bifurcation of our cases. We cannot exhaust on behalf of the federal government. And so recognizing that we're not looking at specific language for change, our weighing is very conceptual, but that is one that I think that we do want to dig in a little bit more and have concerns about. And then in other instances, I have had the opportunity to interact informally with other agencies and with the administration, and also in full transparency that there was a general sense of concern about just any ideas that go forward that would increase the cost of doing business in Colorado and just make it more difficult for small business. So I know in this instance, we're supposed to focus on the ideal, but again, I want to be fully transparent just about some of the reactions that have come forward. And I know we have a long ways to go to unpack this, but I just wanted to mention that for today. So happy to answer any questions if anybody has any of me.
Thank you, Jenny. And I know you'll stick around, so we may tag you in. I do want to make sure folks saw in the folder that there's a folder in that input section called Letters from Associations. You will see letters from the Attorney General relating to some of these issues, or notes from the AG. You have letters from the Colorado Competitive Council, the Denver Metro Chamber, Colorado Association of Home Builders, and the Colorado Chamber of Commerce. And I want to call out the home builders in particular, lest you think that is only about housing. The Colorado Association of Home Builders did have thoughts for the rewrite subcommittee, so I want to call that out. With that, before I open it up, I just want to remind folks how we're approaching all of this. As I said, we'll vote in the three ways of, with minor revisions, let's move this forward. With substantive revisions, I think we still should, or no, this is not, I don't think this should be a recommendation. And as a reminder of process, our report, which will go to the executive committee the 1st of December, and I think it's actually December 2nd is the Monday. We will have all of the records of all of our conversations, including all of these ideas, all of the stakeholder feedback that has been received in any format. Our report itself will list the recommendations that you are advancing. In that, we will name the problem we're looking or working to solve, what the ideal end state is if it's going to take a transition period to get there, what the immediate minimum steps are you all are recommending be taken. All 4 subcommittees will submit similar reports in that structure to the executive committee, who will then spend December listening to more stakeholder input and deciding what their final recommendations will be. So today our task is to have some conversation, and I'll start it off with just some open thoughts and reactions to what I've shared or what you heard or read in the stakeholder input generally. And then, as I said, we'll start going through these one by one, get through as many as we can today, but I'm not going to rush this conversation because I want everyone to have the kind of thoughtful conversation to be comfortable casting a vote in favor or in opposition. With that, I won't start by calling on people, although you know I'm perfectly willing to do so if people are a little shy. What I will do is open it up for anybody to come off mute and lean in on what, if anything, you took away from the stakeholder input I've shared or that you read or heard in that folder. Please, Andrew.
Thank you, Barrick, and good morning. This is Andrew Montoya. Just a quick question for you. Looking at the survey results, it looks like we got only 3 responses to each of the questions, I guess. Is that accurate?
That is accurate. We had very few for this subcommittee.
All right, thank you. Yeah, I'm just kind of looking over the responses that we did get. I mean, I saw a lot of the same sorts of things coming in a lot of the letters from the associations and the chambers of commerce. Same with the comments from the Home Builders Association, which, I mean, I don't mean to be dismissive, but it's generally we're opposed to anything that may potentially increase any potential liability one day if the sky falls. And, you know, frankly, that's always a concern. And I think we've done a pretty good job of coming up with some recommendations that, while being mindful of those concerns, also put the needs of Coloradans with disabilities, who are often put, you know, at the backside of that equation, really at the forefront. And I think that's what we should be doing as this, you know, as this committee moves forward. Our goal, I think, should be to put forward the best set of recommendations that we can, shooting for the stars, recognizing that this, of course, does have to go through the task force, which may make some changes, and then further to the legislature, which will make whatever changes it chooses to as well. So we should shoot for the stars.
I appreciate that, Andrew. And I think everybody's heard me say there is very little likelihood that once you hand it off, people are going to become more bold or more aspirational. It's going to get diluted or additional factors weighed in there. Here's what I just want to say is kind of the tone for these conversations. And Andrew, I agree with everything that you just said. And what I will say is this group is the task force on the rights of Coloradans with disabilities. That is who this task force is intended to advance the rights of. And these associations who have weighed in are doing exactly what they are fiscally required to do. Their obligation is to look out for their members. So I don't want any of us to look at them as any type of bad actors. They are doing what a professional association representing interest does, which is look out for those interests. And I think that is an appropriate role. Ours is to find aspirational solutions or opportunities to remove barriers and to make conditions better for all involved. My hope is we find that common ground, or we make the case for what you all believe. But I just want to say that I hope we all maintain that aspirational view that Andrew is taking, with a level of respect also for those who may disagree with us, because their roles in society call for them to do so. Who else would like to weigh in on how you're thinking about the ideas generally, or what you took away from any of the stakeholder input? Spencer, please. Spencer, I'm not getting your audio. You're not muted, but not coming through.
Okay, how about now?
There, we got you. Yes, sir.
Okay. This is Spencer Kalnick. You know, one of the things that I noticed that was sort of a pattern through a lot of the comments that were submitted was concern about incorporating federal regulations and guidelines, definitions, etc., into state law. I thought that was just interesting in the aspect that there was concern that there would be confusion about how we're applying kata, but from my perspective as an individual of this task force trying to figure out how we can advance individuals with disabilities rights in Colorado by utilizing state law. Essentially what we're doing is we're saying, okay, here's the baseline. And then CADA is Colorado's ability to say, okay, here's the remedies that we're providing to individuals with disabilities that go above the baseline. So any incorporation of the federal definitions, guidelines, remedies that we have incorporated into the statute, that's really just saying, yes, we accept the federal laws sort of baseline in terms of accommodations and definitions that we're going to provide. And then I feel like our job is really to kind of take that next step and say, okay, here's what Colorado's doing beyond that. So that was just one point of clarity. I don't even know if it's clarification, but something that I noticed and I thought was worth addressing and kind of talking about it.
Thank you, Spencer. Anyone else want to offer thoughts or reflections? Okay, what I'm going to do is start taking us through the ideas one by one. We will I'm not going strictly to votes. There will be opportunity as I read each one for folks to offer comments, thoughts, or questions. I will be going through initially the ideas around exhaustion, timelines, and emotional distress damages. The first one here, let's get right at it for my friend Jenny, who just spoke. This has to do with exhausting administrative remedies. The idea as shared is as follows. Amend Colorado revised statutes to remove any requirement for exhausting administrative remedies where such requirement exists relating to claims of discrimination while preserving the right to pursue such remedies at the option of the claimant. So the idea is to remove the requirement while leaving it as an option. As a reminder, the concern that had been raised in our latest stakeholder feedback was whether we get at odds with some of the federal programs and partnerships. And there's been questions raised of, is there the capacity for the division to manage those? The case has been made in favor, and I won't repeat it ad nauseum, but a number of you and others who spoke to this subcommittee raised the desire to bypass that rather than going the dual track and not require everyone to exhaust those remedies. Let me first, before opening up to the floor, ask if either Ginny or Aubrey wants to ground us in anything on these.
Hey, Barrett.
That's you. Yeah.
So I just wanted to add to this, and Aubrey can correct me on the detail, but the bottom line is with this one is that we cannot exhaust on behalf of the federal government for this. So if this particular recommendation does go forward, complainants would lose their rights at the federal level. It would bifurcate our processes and increase workload for complainants when they go through this process, and then also require us to do a duplication of effort. Aubrey, anything else to add?
Sure. Just to add to that, it would require, by bifurcation, we mean it would require two separate analyses, one under CADA and then a separate one under Title VII. So it would be undergoing two investigative routes. And the issue for us with that is that we have a work share agreement with the EEOC, and that's how we get paid to do cases. So we are at jeopardy of losing our contract with the feds on this. And so for those cases where we weren't doing it would no longer be a dual filed case, we would lose payment for those cases because they would be processed only under CADA, since we can't exhaust on behalf of the EEOC.
Thank you, Aubrey.
Thank
and
you.
Let me tell you how I'm going to manage this conversation, what we are going to do and not do. I am going to invite every member to react to any arguments in favor or opposed that you have heard. What I'm not going to do is turn this into a British parliamentary debate that gets heated and goes back and forth. But I want everyone to feel very comfortable weighing in favor, opposed, down the middle, with skepticism, with optimism, with nuance, or with caveats. I want everyone to speak their mind. I just don't want to turn this into a huge back and forth. We've talked about these issues for 10 months. I want everyone to be able to say what's on your mind, if you agree or disagree with something you've said. And then we are going to go to those initial soft votes, temperature checks, and then we'll go to a formal vote. Does anybody, before we go to those voting, have thoughts they want to offer about the exhaustion of administrative remedies and this idea to remove that requirement? Ian, and then Andrew.
This is Ian Kelman. Is this the point in time to express my thoughts that won't lead to a British parliamentary debate, or is that for when we're actually voting and everybody is weighing in?
I appreciate you asking. What I'm going to do is ask everybody to offer their thoughts now. After everybody has offered their thoughts, we'll do that first temperature check vote, and then we'll do a full vote.
Okay. So yeah, I mean, I'm in favor. I mean, I think everyone on the committee understands and has heard me repeat this many times over the last year. I'm in favor of the idea of making exhaustion optional. You know, the exhaustion process does serve a role in some situations, but in others it does not. You know, in a number of cases, it just adds unnecessary delay to people being able to bring their case in court. I don't necessarily know that I agree that making exhaustion optional will result in an increased workload for anyone, because if exhaustion is optional, people who opt not to exhaust won't be filing charges with the CCRD. Therefore, there will not be charges for them to investigate, meaning there won't be any workload. You know, the idea, I understand and have understood for quite a while, the way the work sharing agreement that the EOC and the CCRD have results in the CCRD getting paid. But I have to weigh in and say that I think that if we are trying to be a leader in protecting the rights of individuals with disabilities, and being a leader means providing greater protection than exists under federal law, we have to understand that by providing greater protection that exists than in Colorado than exists under federal law, we may be in a spot where the CCRD is going to have fewer cases that will either be dual filed, or where we will have individuals who won't want their charges dual filed because the federal remedies, you know, either there won't be federal remedies or the federal remedies are not as robust as the remedies that we're trying to implement here. And, you know, I much like I expect the business community to react to our proposals the way they did, because this could potentially result in an increased cost on business. I understand why a potential loss of funding from a work sharing agreement may be concerning to the CCRD. But our goal is to provide the most robust protection possible for individuals with disabilities, not to ensure that a funding source from the federal government remains as large as it might be under other situations. I think that a simple way to address the exhaustion issue as an option can be done at the initial intake stage, where if somebody contacts the CCRD, they can be told they don't have to file a charge and they can go right to court. They can be told that if they do file a charge, they can file a charge only under Colorado law, or they could be told that they could file under a charge under Colorado law and federal law. And then they can make the decision at the time that initial intake is done. And if they opt not to exhaust at all, there's no work. And if they opt to exhaust only under Colorado law, there should be no conflict with the EEOC. And that's a decision that the charging party makes, not the CCRD. And, hopefully the charging party makes the right decision for themselves. But I don't think that what I would call minimal administrative burden is the sort of thing that we ought to be looking at as a deterrent for making this process optional.
Thank you, Ian. Andrew, you were next.
Thank you, Barrick. This is Andrew. A question for you quickly, Barrick. Would it be appropriate to ask a question of Ginny of one of the things that she said?
If it's a question of clarification, I will welcome it.
Okay, thank you. So Ginny, this question is for you. I believe I heard you say something about folks would lose their federal rights or ability to bring a federal claim, something like that. And I just wanted to clarify how that would be, or, I guess whether that right would be preserved by still filing directly with the EEOC.
And I'll actually have to have a lifeline to Aubrey, but my understanding is that it deals with the Title VII protections. So Aubrey, can you jump on and provide the detail for that, please?
So I think that in order to preserve that the Title VII protections, they would have to file independently separate with the EEOC. It would not be a dual filed case. So they'd have, whatever case they were taking directly, if they didn't file with our office under CADA and they didn't exhaust, and then they'd file another case with the EEOC. But also keep in mind, this is one of the things where I think we talked about with our process versus the EEOC. The argument is that people don't want to exhaust because it takes a lot of time, but our office actually has jurisdictional deadlines of 450 days where the EEOC does not. The EEOC does not have jurisdictional deadlines, and they can hold on for a case as long as they want. So that's just some information to keep in mind as well.
Okay, thank you very much.
You're welcome.
So yeah, I mean, with that, I just kind of wanted to clarify that to the extent that we're talking about exhausting administrative remedies, really the only area that we are talking is in employment. Both public accommodations and public entity claims have already been accepted from the requirement to exhaust under state law. And I believe housing claims, it's optional already if someone wants to file with the CCRD. So at this point, we're really talking only about employment. And I would kind of echo what Ian was saying earlier that, in our experience, one of the reasons that our office has never done employment claims is because of the exhaustion requirement. We can't even, touch a claim really until it's gone through that exhaustion process. So we, to the extent that we get intakes that involve employment claims, we unfortunately have to turn them down and say, go file an administrative complaint and let us know what they say after the fact. So to the extent that we can kind of short circuit that and bring folks with meritorious claims who want to file those claims directly in court, I think it makes sense to do so.
Thank you, Andrew. Does anyone else want to weigh in on this before we go to the straw poll on this? Alana.
Thanks, Barrick. This is Alana. I had one more, point of clarification. I just wanted to make sure I was understanding in the right direction. Beyond just kind of broad concerns of making sure that any procedural changes we make one way or the other are clearly communicated to anyone who wants to file one way or the other, to make sure that any decision they make is one where they understand all of the impacts, both short and long term, to the case. I would assume everybody's going to make the right decision for them. I just want to make sure that we're doing anything we can to make sure all potential complications are being communicated to them. But the other thing I wanted to check is I think I heard the phrase at risk of losing the contract or something for the funding. And I wanted to clarify, if possible, whether that is a case-by-case basis of just if the case isn't dual filed, won't get funding for any work done on that case, or if that was a broader thing of if there's like the number of dual cases filed falls below some certain threshold, if all funding would be lost, just because that would be a different impact.
Good questions, Alana. Aubrey, are you able to clarify on that?
I think so. I think for right now, from what I know, without talking directly with the EEOC, I think it's on a case-by-case basis. So I think that as long as there's, that bifurcation and we don't have as many cases, that it's okay. But I can't speak to like the totality of what would happen with our entire contract without speaking with the EEOC first. I don't think that we would be at loss of losing the whole thing. I think with what you were saying about making sure that people that file are able and they know which routes to take, I think something also to mention with that is if we have to educate people at the beginning of when they contact our office, our intake at our office, you have to remember that we can't provide legal advice for them too. So we can give them the different routes that they can take, but then if they ask questions and they happen to be pro se parties that are not represented by an attorney, we're not going to be able to tell them, well, you can get these damages under this or these damages under this, and this is what we think that you should do. So that's something to consider as well.
Okay. What I'm going to do is ask folks, and you can use your physical hand or you can use the little reaction button to raise a hand. 3 ways I'll give you the chance to vote. Move this forward as a recommendation substantially as is with little or minor revisions, and then we'll talk about those. Move this forward, but first it needs substantial revisions, or do not move this forward. The hands of those who would say, move this forward as a recommendation with little or no revisions as written. I have 6 hands there. Those who would put your hands down if you would. Thank you. Would anybody vote to move it forward with substantive revisions? I have 1 vote to move it forward with substantive revisions. Would anybody vote not to move this forward? I have 1 vote not to move it forward. We can go to a vote to formalize it, but Tom and Lauren, I first want to offer you the opportunity to express your point of view on, Tom, in your case, what substantive revisions you think are needed, and Lauren, if you'd like to offer reasons for opposing. Tom?
Unless I'm not tracking this correctly, I think really making it to where we can really make it clear that it's optional. That the more options people have, I think the better things are, if we can make that happen.
Tom, as written, it does say to remove the requirement and preserve the right to pursue at the option of the claimant. Do you think that needs to be strengthened even more to underscore that?
I think so.
Is there any language you would offer for consideration?
To make it simple, just really clarify that they've got the option to file directly or to exhaust as well. Just make it clear that they can have that option.
Those who voted said that you'd be in favor. Would anybody be opposed to an introductory sentence underscoring we are eliminating the requirement while maintaining the option of exhausting administrative remedies? Lauren, let's go to you on you had voted to oppose, and I think I just saw your hand up on this discussion.
Maybe I misunderstood what we're voting on or opposing. So let me clarify my opposed vote.
Yep.
And for moving this forward, knowing that the idea is going to be discussed in the final report, but my vote's going to remain no. And even in our conversation with those of us in the room, some of the advocates who said that the CCRD has worked really well for you and their investigative process is superb. And it was my understanding that is why the EEOC has partnered with the CCRD. It's worked well for both businesses and for those who are filing a claim, and it's a fair process that's worked well. And I think you could see from the feedback that business communities feel like it's working well. And if we make it optional, you might as well jettison the CCRD. Optional doesn't really mean that you're basically eliminating the entire process if it's optional. It's like saying it's optional to follow the speed limit. Why have a speed limit?
Understood. Lauren, I appreciate you speaking up. I am going to go to a roll call vote, and we will have the option to include your thoughts as you just shared, or I'm happy to follow up with you depending on where this vote goes. The vote I will take, and it will be a roll call, is to include the recommendation for removing the requirement to exhaust administrative remedies where it exists while preserving the option, with the addition of an introductory sentence to emphasize that we are removing the requirement while preserving the option. That said, I will now ask for a yay or nay or a yes or no, and I'm going to go through a roll call. Alana,
Yay.
Andrew Montoya,
Yes.
Cindy Vaughn,
Yeah, yes, and I apologize for being off camera. I have a respiratory thing going on.
understood. Ian Kalmanowitz,
Yes.
Lauren Schwartz,
No.
Spencer Kotnick,
Yes.
Tom Aker,
Yes.
Tom Wheaton.
Yes.
The idea will move forward as a recommendation with one opposed. And Lauren, I'm happy to follow up with you to discuss language to include in the report with the explanation of the objection. I'm going to move us on to the next idea. This one has to do with the statute of limitations. I'll read it. I'll remind folks some of the ideas that were raised around pros and cons. We'll open it for discussion, go through the same voting process. Amend Colorado revised statutes relating to the timeline or statute of limitations to 3 years for any claim of discrimination by an individual with a disability relating to housing, employment, or by and against a public entity or relating to a public accommodation. There's a note included that the subcommittee discussions focus on the rights of individuals with disabilities, while noting the different types of claims in Part 6 versus Part 8. It is the intention of the subcommittee in this idea to standardize timelines and rights across all types of claims, including Parts 6 and 8. As a reminder, some of you in our discussions weighed in advocating for this standardization so there was simple consistency in the timeline for filing these claims rather than a variety of different ones. We have heard some concerns expressed by different stakeholders in state government and outside stakeholders that this could put things at 3 years. There were concerns raised about things like record keeping or memories and recollections of events that took place. There were also those who raised concerns about alignment with other types of claims, and should some of these remain at 300 while others go to 365. That said, let me open it up to the group on first a voluntary before a voluntold basis for thoughts or reactions you'd like considered as we move to a vote. Is there anybody who would like to weigh in on what you've heard or your thoughts on this issue of standardizing everything to 3 years? Mr. Montoya, I see you trying to come off mute, so I'm just going to go ahead and call you.
Thank you, Barrick. And I, in fact, was not trying to come off mute. I was trying to pull up the recommendations. But I will just generally say I am in favor of this. One of the things that we've often encountered is, especially when you're talking about disability rights claims against public entities and public accommodations, folks have a difficult time finding attorneys. There's not a whole lot of attorneys in Colorado or even nationwide that do this sort of work. So sometimes it can take easily a year and a half for someone to find an attorney who does this sort of work that's going to be able to take the case and not charge them an arm and a leg. For instance, our office does not charge folks. We seek to recover fees on the back end as part of fee shifting under these laws. And there's not a lot of offices that are willing to front those sorts of costs and attorneys' fees, despite how meritorious the case may be. So to the extent that we can allow folks with disabilities more time to find that counsel or decide which of these options they want to take with respect to exhaustion, I think that would be all the better for Coloradans with disabilities.
Thank you, Andrew. And just to remind folks on the current law, which is 2434, 402, 502, and 602, allows filing deadlines after the alleged incident of 300 days for employment, 1 year for housing, and 60 days for public accommodations. The division is statutorily required to complete their investigation within 450 days. So based on today's deadlines and completion, could take up to 750 days for filing and investigating employment discrimination cases. Housing discrimination could be 815 days, and public accommodation 510. But that is the origin of your conversations. Just to remind you of where we started, this was those discrepancies when it comes to 300 days for employment, a year, 300 days for employment, 1 year for housing, and the 60 days for public accommodations. Cindy Vaughn.
Yeah, this is Cindy. And I don't know if this is okay or not, but I wanted to get some clarification from Aubrey and Jenny, because I'm not sure they reference this, and so I'm not sure if I missed it. But would this timeline shift have an impact on the work share agreement that we currently have with EEOC?
Thank you, Cindy. And Jenny, I'm going to punt to Aubrey for you. Aubrey, would adjusting these timelines to all be 3 years affect that work share agreement with the feds?
Well, I think it kind of would go to what Ian was saying before in terms of, well, the cases wouldn't be filed with, us or the EEOC. They're not going to be filed with us if they're taking them and, pursuing the CADA claims. With respect to the EEOC, the answer, I think, is it depends. We don't know, and we would need to get substantive feedback from the EEOC, so it might affect what they say. I think that the biggest concern for us with the shift in the timeline is just the increase in cases that we could see as well. In referencing the having more time to file, we went from a couple of years ago from having 6 months for employment cases. There was 6 months for time to file, and then we went to 300 days from that. As a result, we have seen in employment cases a 36% increase in case filings. So that's something that we're looking at right now, is just what that number could look like going forward, as well as the, loss of memories, lack of available records, etc.
Thank you, Aubrey.
Thank you.
Any other members clarifying questions or thoughts you'd like to offer before? Let me go to Ian and then Spencer.
Thanks, Barrick. Ian Kalmanowitz. I can't speak to the specifics of the impact on the work sharing agreement with the EEOC in response to the question Cindy just asked, but I will add that if we change the statute of limitations to 3 years, we are not able, and again, this is only for employment cases where a person with a disability has 300 days to exhaust with the EEOC under the Americans with Disabilities Act. If we were to change that statute of limitation to 3 years, we're not changing the statute of limitations for exhaustion with the EEOC. And so if somebody waits a year or 2 years and then wants to exhaust, they will have lost their right to exhaust under the ADA with the EEOC and would only be able to exhaust under CADA. So I want to just make sure that everyone understands that, should we make this change and somebody waits more than that 300 days, they're not going to be able to exhaust with the EEOC at all. With respect to the concerns about loss of memories that we've heard by lengthening this, I want to raise a couple of points about that. The Rehabilitation Act that we've talked about quite a bit over the last year, which is one of the federal laws that prohibits disability discrimination. That's the law that was negatively impacted by the Cummings decision, has a 2-year statute of limitations. 42 U.S.C. Section 1981, which is a federal law that prohibits employment discrimination and discrimination on the basis of contracting because of race, has a 4-year statute of limitations. In Colorado, all contract actions have a 3-year statute of limitations unless they're a contract action for a liquidated amount of money, which means it's a 6-year statute of limitations. Actions for fraud, misrepresentation, breach of fiduciary duty, violations of the Uniform Consumer Credit Code, replevin, I'm going down the list, tort actions for bodily injury resulting out of the use or operation of a motor vehicle, all have a 3-year statute of limitations. And so these are all, in particular, a lot of these like contract, breach of fiduciary duty, violation of the Uniform Consumer Credit Code, replevin. These are all the kind of claims that businesses deal with routinely if they're involved in litigation. And no one has raised a concern about document retention or loss of memory or loss of access to witnesses. It is a problem. I mean, I will say it as somebody who goes through a 750-day or longer delay during an administrative exhaustion process. We do wind up with cases where we can't find witnesses, people's memories fade, but that's not because of the statute of limitations. It's just because of the passage of time. I don't think this is a concern that we ought to, back away from the proposal of the 3-year statute of limitations, because there are so many other legal claims that could be brought within 3 or more years. And this has not ever been raised as an issue in any of those other claims.
Thank you, Ian. Spencer.
Yeah, so I mean, I think Ian hit on a lot of what I was going to address with respect to the statute of limitations as it relates to the EEOC and the CCID. But I was also going to talk a little bit about written contracts and how the statute of limitations is 3 years. So, I mean, in a lot of employment cases right now, if you have a claim that is premised on the employment contract, which a lot of employees in Colorado do, they've got a 3-year statute of limitations in which they can bring that claim. And then if it's disability, it's subject to very different standards that we currently have in terms of filing requirements. So, this change, as Ian emphasized with numerous other statutes, just kind of brings it in line with other claims that generally accept a 3-year statute of limitations period.
Thank you, Spencer. At this point, I'm going to go to the straw poll. Fair warning, I'm going to go in reverse order this time. And the question first will be, is there anyone who would vote opposed, vote that this idea should not go forward as a recommendation? I see 1 vote for opposed to this idea. The next option will be, is there anyone who would vote for this, but with substantial or substantive revisions to what was shared with stakeholders? I see 1 vote there. Alana, do you want to share what that is before I go to the next vote option?
Yeah, Eric, and this is Alana. This might be something that was originally included, and I'm not remembering the phrasing well enough. But anywhere where we're shifting anything to, I know we're simplifying ideally and bringing it in alignment with many deadlines, but it sounds like it might be coming out of alignment with some of at least one federal deadline. So if people go past a certain time, they would still be able to now file here, but no longer with the federal government. I don't think that's necessarily a bad thing. More options are generally good. I just want to make sure that we're including some sort of language so that people are aware of this impact. I know for the lawyers among us, for anyone who has been dealing with things like this throughout their life, they're probably more aware of the law than many lawyers are. So they already know a lot of this, but I'm thinking for anyone who is new to the process, new to the system, anything like that, I'm just worried about us shifting the ground under their feet and them accidentally stumbling into consequences of filing a day later because they think they now have time and they've accidentally opted themselves out of the federal side, anything like that. So just kind of, I guess, a warning or a disclaimer or something in the language to make that clear.
So just so I don't put words in your mouth, but I try to read back and clarify. You're not proposing any change to the idea or the recommendation itself, but you are proposing language be included in the report to the executive committee regarding the implementation and the clear communication about what has changed and the implications of it. Is that correct?
Yeah, I basically just really like solid documentation.
I'm going to move on to, without yet addressing Alana's proposed note on implementation, sticking strictly to the idea, the hands of those in favor of moving it forward as is or with minor revisions. I have 6 hands in favor there. Would any of those in favor have concern about including Alana's suggested note regarding implementation and clear communication of the implications and incongruity potentially of state and federal?
This
I
is Cindy.
Yes, Cindy.
I'm sorry. I actually wanted to go back to a point of clarification or point of order from you. Can you please indicate who is voting what when you read those numbers? That would be helpful.
I absolutely will do that, and thank you, Cindy. If it's okay with you, I'm going to go to a roll call vote, and we'll get it on that one. And in the future, I will be sure to call out who's voting which way.
And I am in favor of adding what Alana has asked for.
Okay. So the idea in front and the vote will be whether to advance as a recommendation the standardization to 3 years for all types of cases, with a bolded italicized footnote on implementation to be very clear on explaining the implications and the potential incongruity with any other pathways, including federal. Because I'm going in alphabetical by first name, Alana Barris, you are first.
Yes.
Andrew Montoya.
Yes.
Cindy Vaughn.
Yes.
Ian Kalmanowitz.
Yes.
Lauren Schwartz.
No.
Spencer Kotnick.
Yes.
Tom Aker.
Yes.
Tom Wheaton.
Yes.
By a vote of 7-1, the idea will advance as a recommendation from the subcommittee. I will follow up with the no votes to ensure we include any requested language in our report. I will now move us on to our next one. I will remind as I read this, this was specifically a legislative directive to address the issue of emotional distress damages. We were required by legislation to examine this. The idea reads as follows. Amend Colorado revised statutes to allow an individual with a disability who has been discriminated against by a government agency or public business to pursue emotional distress damages. Just some notes, this would be through revisions to CRS 2434-802 and elsewhere as necessary. For now, we are not addressing the issue of caps or the amount of damages. We are strictly speaking to the right to pursue emotional distress damages when an individual has been discriminated against by a government agency or public business. I will share again that some of the discussion about this over our time together over the past year has been about the fact that some shared that there were damages experienced that could not be remedied other than by pursuing emotional distress damages. One person has highlighted the incident, for example, of missing a child's graduation. That's not something that could be made up or altered after the fact. In some of our stakeholder feedback over the course of the year and in our more recent open solicitation of input, there were concerns that this could open up a unfriendly business environment, that this could lead to frivolous or excessive lawsuits. And the issue was raised by several that emotional distress damages are not quantifiable or difficult to quantify. I'm making no opinion or offering any on any of those ideas in support or opposition, just sharing what we've discussed and what we've heard. Before we go to the straw poll, does anybody want to offer thoughts on allowing the pursuit of emotional distress damages in the event of discrimination by a government or public business? Again, not speaking yet to the amount of damages or caps. Andrew.
Thank you, Barrick. This is Andrew. This question of emotional distress damages really is why we are here. The legislation that put together the task force and these subcommittees ultimately was spawned by an effort in the previous legislative session to include emotional distress damages for people with disabilities subjected to discrimination by public entities and public accommodations. And to give you the bit of a historical perspective on that, we used to be able to get those damages until the Supreme Court kind of yanked the rug out from under us a couple of terms ago in the Cummings case. Prior to that case, we used to be able to pursue emotional distress damages against public accommodations that accepted federal funds, at least, and public entities on behalf of people with disabilities when they were subjected to discrimination by one of those entities. After Cummings essentially decided that the only available remedies are those available under contract, which tend to exclude emotional distress damages. As a result, we are no longer allowed to get emotional distress damages for people with disabilities under state or federal law at all. And that needs to change, because when you're talking about disability discrimination, it really is a matter of emotional distress. You're not talking about someone most often who's lost out on a whole lot of money or some huge business opportunity. You're talking about the indignities of not being able to get up on a curb because there's not a ramp, of missing out on parenting time with your children because law enforcement decides that you have a disability and you can't be a good parent, or the example that Barrett gave earlier, someone missing out on their child's graduations, the sort of thing that you can't get back. And really, the only way that the law can remedy those wrongs is with money. Sure, we can pursue injunctive relief to make sure it doesn't happen again to someone in the future in some circumstances, but even that is hard. But that does nothing to make the situation right for the person who is subjected to discrimination. So that's why we are here, is to improve Colorado law, to restore the right for people with disabilities to get emotional distress damages in these claims. Some of the comments that we saw are concerns about frivolous lawsuits. There's already another statute in Colorado, in I believe it's Title 13, that prohibits bringing frivolous or vexatious lawsuits, and indeed allows for fee shifting against the person who's brought a frivolous lawsuit. So protections against that sort of thing already exist. What we're trying to do is restore the protections for people with disabilities that the Supreme Court ripped away a few terms ago in the Cummings decision, and put people with disabilities on the same footing that other people are who are subjected to discrimination and able to get emotional distress damages.
Thank you, Andrew. And I do want to just remind anyone who is joining not from the subcommittee and listening in, we're talking about a narrow piece of CADA on this. This relates to discrimination by government or a place of public accommodation. Part 4, which is employment, already provides the right for emotional distress damages. As Andrew was saying, the Cummings decision that found that the Rehabilitation Act did not provide that right here. Any other members want to offer thoughts, questions, or points of perspective before we go to a straw poll on this? Ian, please.
Thank you, Eric. Ian Kelman Woods. Andrew, the notes I made while Andrew, or you and Andrew were talking, Andrew touched on the frivolous issue, which is a common refrain that we hear from, trade groups and associations. And as you noted at the outset of the meeting today, they're doing their job. But the frivolous issue is something that there already is a remedy there to deal with potentially frivolous lawsuits. I wanted to add that, in the context of public accommodation, emotional distress damages can be available for other types of discrimination based on use of other statutes that exist. So it really is there's a hole in the law here that really applies detrimentally to individuals with disabilities, and this would be plugging that hole and remedying that situation. The other issue, with one of the concerns that was raised by opponents of this is that these emotional distress damages are not quantifiable. And, we as a committee have discussed that quite a bit over the last year. And they're quantifiable by a jury. And, they're quantifiable by a jury in the cases of employment discrimination. They're quantifiable by a jury in the cases of housing discrimination. They're quantifiable by a jury in the case of negligence. If a business owner is negligent in the maintenance of its property and somebody falls and injures themselves and brings a claim for emotional distress damages, a jury will make a decision about what those damages are. That's how these are quantifiable. And this is not injecting some sort of new damages regime or rubric into the law that is unheard of, that no one will know how to deal with because it already exists. And anybody who may be subject to these damages is already subject to them in many other aspects of the way they conduct their operations as a governmental entity or business as a private business.
Thank you. Tom Wheaton.
Well, I just want to thank Andrew and Ian because I think they articulated the heart of their discussions and certainly my stance over this last year. They just articulate in ways that I can't. So I want to thank them both because that's exactly how I feel.
Thank you. Other members? Okay, to make sure you're all paying attention, I'm going to mix up the order yet again. We'll have the three options. The first option, I'll see if anybody wants to vote to advance the recommendation with substantial revisions to what was written. I have no votes that direction. Vote to advance the recommendation as is or with minor revisions. I have 7 votes that direction to advance as is. Do I have any votes in opposition? I have 1 vote from Lauren Schwartz in opposition. I will now do the formal roll call vote. And again, keeping you on your toes, I'm going to mix up the order and go backwards. The vote is on our idea to amend Colorado revised statutes to allow an individual with a disability who has been discriminated against by a government agency or public business to pursue emotional distress damages. I will first go to Tom Wheaton.
Yes.
Tom Aker.
Yes.
Spencer Kotnick.
Yes.
Lauren Schwartz.
No.
Ian Kalmanowitz.
Yes.
Cindy Vaughn.
Yes.
Andrew Montoya.
Yes.
Alana Barras.
Yes.
And Alana, I realize today is the first time I'm regularly reading your last name, so correct me if I'm mispronouncing it.
No, you're good. Thank you.
That we've been on a first name basis for so long here. By a vote of 7-1, the idea to allow emotional distress damages will move forward as a recommendation with the opportunity for those in the minority to include a explanation or a note in our report. I am now going to go to several of the ideas around caps. I'm going to read each of them because there are different ideas contained here. And I think it's important that we put all of these on the table. We will then discuss them as a group and then vote on them individually. Idea, amend Colorado revised statutes as above, that's the addition of the emotional distress damages, and set no cap or limit on the amount of damages that could be awarded. We did include a note to stakeholders that juries are not typically informed of caps during the trials or deliberations. The next idea, amend Colorado revised statutes as contemplated to add the emotional distress damages and establish therein a cap or limit on damages that could be awarded with such caps consistent with those set in other civil proceedings and in amounts to be recommended based on stakeholder input and further discussions. The next one does not directly relate to caps and we'll address it separately, but I want to read it out now as a reminder that this is on the table. This idea is as follows. Amend Colorado revised statutes as contemplated in item 3 above, that's the addition of emotional distress damages, and further amend to allow plaintiffs to seek and recover additional punitive damages if affirmative intent to violate the underlying statute is proven to the appropriate standard by plaintiff. So you have voted by 7-1 to recommend the allowing emotional distress damages. We have 3 ideas we will talk through, 2 of them together. 2 of them involved caps. One says set no caps. One says with further work, establish a schedule that is consistent with other civil proceedings and in amounts to be recommended based on stakeholder input. After we get through caps, we'll talk about the punitive damages. In talking about these two ideas of setting a schedule of caps or setting no limit on the amounts, who would like to offer any thoughts or perspectives for the group to consider? Tom Wheat.
Yeah, Tom Wheaton here. As we discussed before, I don't like trying to convolute the issue with trying to figure out caps. I'm a proponent of no caps.
Understood. Thank you. Other thoughts on saying there are no caps, setting a schedule of caps? Ian Kalmanowitz.
Thanks, Barry. Ian Kalmanowitz. I just want to reiterate some of the points that have come up over the last year, in particular with respect to where the caps exist right now, which is in the context of employment. They're set. Well, first they were set in 1991 by Congress in amending Title VII, and those caps have never changed in the intervening 33 years. And when damages were added to CADA, I'll remind everyone that there were no emotional distress damages available for employment claims under CADA until 2015. And when those caps were added, or those damages were added in 2015, they were subject to the same caps that exist under federal law. However, for smaller employers that have fewer than 15 employees, those caps are even smaller. And as we've discussed over the last year, those caps don't take into account the revenue generated by a business, the profitability of a business. All they are based on is the number of employees employed at a business. And it's an arbitrary way of determining where the amount of damage that is recoverable by an injured party can be cut off. And so, for those reasons, I'm opposed to these caps.
Thank you, Ian. And for those just joining the task force for today's call or who haven't had the benefit of the last year's worth of conversations, as Ian referenced, we explored a number of different scaling options or schedules of damages. As Ian referenced, looking to the federal schedule, it looks at strictly headcount. We explored as a subcommittee everything from gross revenue to EBITDA, earnings before income tax deductions and allowances, to things like net profit, to things like how many locations. And ultimately, this group decided not to put forward an idea that had that schedule. And that's how we landed on these ideas of no caps or a to be determined schedule. Does anybody else want to offer thoughts on caps or no caps? Andrew Montoya.
Thank you, Barrick. This is Andrew. I would just kind of echo everything that Ian and Tom have said about having no caps. I also want to raise the fact that caps, as Ian said, are more a creature of employment law. That's not something that has existed before with respect to public accommodations or housing or public entities. So to the extent that we are imposing caps on other damages, those would be, first time caps. And I don't think that's what we're looking to do in this subcommittee is impose additional limitations on the recoveries of people with disabilities. So for all of those reasons that they said and that additional reason, I would say that I'm in favor of no caps.
Heard the comments. Unless there's objection, I think we can go straight to a roll call. Is there an objection to a roll call vote? Okay, we will go to a roll call. We're going to do each of them separately, so we have them on record. The first roll call vote will be to set, and this is again for emotional distress damages only, set no cap or limit on the amount of damages that could be awarded. Alana.
Yes.
Andrew.
Yes.
Cindy.
Yes.
Ian.
Yes.
Lauren.
No.
Spencer.
Yes.
Tom Aker.
Yes.
Tom Wheaton.
Yes.
By a vote of 7-1, the recommendation to set no caps on emotional distress damages will move forward as a recommendation with the opportunity to include notes of the rationale, or points of consideration for the objection. Although we have now said that we will set no caps, I have an obligation to clear the deck of all items before us, which means we will next take a roll call vote on setting a schedule on limits or caps. We'll just go in the same order. Alana.
I apologize. Can you repeat the thing one more
Yes.
time?
We are now having voted to set no cap. Lauren, did you have a question?
Yes, I'd like some clarification because there was a third option.
The third is a separate issue. It relates to punitive damages separate from the emotional distress damages or in addition to, and we will have a separate discussion on that one next.
Okay, and then another clarifying, is there an option to make no change to the statute as it is today?
There is one that we will be taking a vote on following the punitive damages. And that idea, so you know, says make no damages to Colorado Revised statutes relating to the right of an individual who has been discriminated against by a government agency or public business to pursue emotional distress damages. So we will take a vote on that one in just a few minutes. So we have voted to advance the recommendation of setting no limit because it was an idea shared with the public. I do want to get us on record with the idea that was shared to set a limit on the amount of damages while allowing those damages to be pursued. Alana.
No.
Andrew.
No.
Cindy.
No.
Ian.
No.
Lauren.
Yes.
Spencer.
No.
Tom. Baker, excuse me.
No.
Tom Wheaton.
No.
By a vote of 7-1, that does not go forward with the opportunity to include notes from those in the minority. Our next idea relates to punitive damages. Amend Colorado revised statutes as contemplated in item 3 being the allowance of emotional distress damages, and further amend to allow plaintiffs to seek and recover additional punitive damages if affirmative intent to violate the underlying statute is proven to the appropriate standard by plaintiff. Just a quick reminder without going down rabbit holes, we had some conversation over the last 10 months that at times there has been an egregious violation and that some members argued that there should be the ability to seek punitive damages, whether that was egregious, whether that was intentional repeat offenses. Some of the ideas that we've heard back both during our last 10 months together and during the stakeholder feedback was that this heightens the degree of an unfriendly business environment, that this could lead to excessive verdicts, that this could be damaging to our business environment and climate, and that if we were already removing caps, some argued that there was not a need to add additional punitive damages. Again, I offer these only as a recitation of what we have spoken of and offer no opinion in favor or in opposition. Does anybody want to weigh in with a point of perspective on punitive damages in the event of discrimination by a government agency or public business? Cindy.
Yeah, this is Cindy, and I know that probably 99% of the cases don't necessarily rise to this level, but we have discussed there are still some today that probably would. We've discussed some of the issues around transporting people and these rideshare options, Uber, Lyft, etc., and the issues that continue to happen. And I'm just giving this example, but when an employer continues to have, issues going on with employees demonstrating what results in discriminatory behavior, then I think that there's something to be said for having this piece there in the law to say, the law does mean something. There is something that a person with a disability can do.
Thank you, Cindy. Any other members want to offer thoughts in favor or opposed to adding a punitive damages provision to the revised statutes? Spencer.
Yeah, this is Spencer. I'll just add in, I mean, this has kind of been a consistent point of discussion throughout a lot of this. A lot of other legislation already allows for punitive damages and discrimination components when it relates to something other than disability discrimination. For example, if an individual is discriminated against in a place of public accommodation based on their race or their national origin, they can sue, and to the extent that the place of public accommodation did not rising to that level that, you know, the law has said you can recover punitive damages. In instances when it is disability discrimination, right now the law says you cannot do that. So allowing for punitive damages puts individuals with disabilities on an equal footing and an equal playing field as other suspect classes. And so I think this is very important in terms of ensuring that we are providing individuals with disabilities the same types of protections.
Thank you. Ian.
Thanks, Barrick. Ian Kalmanowitz. Agree with everything Spencer just said. I want to add the purpose of punitive damages is twofold. One, it is to punish a wrongdoer who engages in misconduct. So it is to punish somebody who engages in intentional discrimination. The second purpose of punitive damages is also to provide a warning to others. So it's to serve as a deterrent effect. That is an instruction that courts give juries when punitive damages are at issue in these kind of cases. And allowing for these damages to be available for all types of discrimination, all suspect classes, and whether it's employment, housing, or public accommodation, will do exactly what it's supposed to do, which is provide that deterrent effect to let in, businesses, individuals, landlords, employers know that if they do not take steps to prevent discrimination, that they may be subject to this punishment. And the intended effect of that would be to reduce litigation, not increase it, because it will engender compliance with the law, as opposed to the situation we're in now, where somebody's subject to a fine of a small dollar amount or no punitive damages and a small cap. So the deterrent effect here is a key thing for everyone to keep in mind in why we should move this forward.
Thank you, Ian. Andrew.
Thank you, Barrick. This is Andrew. Absolutely agreeing with everything that's been said already. I want to put, an additional point on this too. Section 504 of the Rehabilitation Act, which prohibits disability discrimination, has been the law since the 70s. The ADA became the law in the 90s. We're working on about 50 years here of notice that these entities have had that they cannot discriminate against people with disabilities. To the extent that this discrimination still is happening, but not only is happening, but is happening with the intent that would need to be shown to get the punitive damages we're talking about, it's certainly more than appropriate that these entities be subject to those punitive damages. One consideration that we have is, businesses sometimes will sit back and wait to make a change because it would be costly to do so, knowing full well that that is causing discrimination, but they can sit back and wait to be sued and then make that change later, make that change later and potentially try and moot the case or limit damages in some way. It's time that we get past that sort of a system and start punishing these businesses for not taking active steps at compliance. Looking at contract law, for example, breaches of contract are allowed because there are some situations in which it is more economically advantageous for the businesses to do so. So as a matter of public policy, the courts have said that's okay, but if you breach a contract, then you've got to pay the other side back for what they expected to get under that contract. But here the public policy is different. It's not a matter of just dollars and cents. It's a matter of making the world more accessible for people with disabilities. So to the extent that we are talking, as the state of Colorado, making recommendations for how the state is going to speak from public policy perspective, we certainly need to put people with disabilities at the forefront of these accessibility changes.
Thank you, Andrew. Before we go to a vote, does anybody want to suggest there needs to be substantive changes or revisions to this idea? Okay, we will go to a roll call vote to further amend Colorado Revised Statutes to allow plaintiffs to seek and recover additional punitive damages if affirmative intent to violate the underlying statute is proven to the appropriate standard by plaintiff. We'll go in reverse order, starting with Tom Wheaton.
Yes.
Tom Aker.
Yes.
Spencer Kotnick.
Yes.
Lauren Schwartz.
No.
Ian Kalmanowitz.
Yes.
Cindy Vaughn.
Yes.
Andrew Montoya.
Yes.
Alana Barris.
Yes.
Our final vote for today: make no changes to Colorado Revised Statutes relating to the right of an individual with a disability who's been discriminated against by a government agency or public business to pursue emotional distress damages. This may seem a little counterintuitive that I'm calling for a roll call vote on this after we've had the votes we have, but this is an idea you all agree we would share with stakeholders, and I have an obligation to recall a roll call vote on whether we should make a recommendation to make no changes relating regarding the right to seek emotional distress damages. Alana.
No.
Andrew.
No.
Cindy.
No.
Ian.
No.
Lauren.
Yes.
Spencer.
No.
Tom Aker.
No.
Tom Wheaton.
No.
Thank you all. With 4 minutes to go, and I hope nobody felt rushed, we got through half. In our next conversation, we will talk through incorporating different standards and regs into Colorado law. We will talk about codifying into Colorado law the deference that was originally there in Chevron versus Natural Resources Defense Council. And we will look at some of the other issues of incorporating caps established for damages by the ADA to eliminate all damages for discrimination relating to housing, employment, and access to a public entity. But we got through about half of our ideas today. I want to thank everyone for everything that has gotten us here. And again, just remind you where we're going to go from here. These ideas, your recommendations, will go into a report. We'll share with all of you to make sure we've captured it correctly. And there'll be opportunity for some group editing of that. We'll identify what is the problem you identified that needed to be solved, what the North Star is or the end state you're looking to create, what the immediate things are that you think need to be in terms of steps taken. There'll also be the opportunity to include minority opinions in that. To the extent we continue to get ideas or feedback in the form of letters or surveys between now and our next meeting, we will get those out to you at least 48 hours in advance. I do want to, thank everyone for the civil discourse. I know not everybody loves what the feedback was that we got or the ideas or the votes. And I want to recognize for anybody who is on the call or is thinking about submitting ideas, we want to encourage and solicit feedback of all types and recognize that everyone who is doing it, we take it as being in good faith, that is their opinion based on the point of view or the work that they do. And I thank everyone for considering the input that you received from different stakeholders. With that, I want to thank everybody. We will get these memorialized and we'll be sharing all of these when we have our second call in 2 weeks. Carrie, can you remind of when our call is week after next?
Put me on the spot there, Barrick. Hang on. It is, I believe it's the 12th because the 11th is Veterans Day. Yes, it is Tuesday, November 12th at 9:30.
So with that, if anybody, either who supported or opposed any of the votes, has specific language or points you want included in the report, please reach out to me. Happy to take them by email. I'm also happy to jump on the phone and take notes. I want to capture and make sure that the reasons voting in favor or opposed are fairly reflected in the report. The executive committee has the right to take or dismiss any recommendations we make. So to the extent we can do our job in making the case for or against, it will help inform their work as they have their discussions in December and continue stakeholder input. With that, and at 1 p.m. sharp, thank you all. I will see you on the morning of the 12th.
Thanks, everyone.
Thanks all.
Thanks, everyone.